In a series of judgments, the Supreme Court has in recent times asserted a salutary principle under the bail jurisprudence, and that is, bail is the rule and jail an exception. Through these judgments, the Supreme Court has reminded the high courts and trial courts that they should not play safe when it comes to granting bail, and protection of an individual's liberty is sacrosanct. Now, why are these judgments being hailed as significant or landmark rulings? To discuss more on this and throw some insight into these rulings, we have with us Senior Supreme Court Advocate Sunil Fernandes, who will talk about not just these judgments, but why these judgments are considered to be important. Welcome, Sunil,
Hello,
to the print. Welcome back.
Thank you.
Yeah. So, my first question to you, Sunil. Bail is the rule and jail an exception is a very well established principle which we often hear in criminal cases. So why is it that these judgments are being now, touted as significant?
So if I can just give you a background, so that we come to just if we start from the beginning, we'll come to know as to why this has become so important.
Yeah.
See, usually our criminal laws strive to have a balance between the rights of the prosecution and the rights of the accused. Both should have a level playing field. And bail is one of the most crucial aspects of personal liberty, because whatever may be other aspects of your criminal prosecution, bail is something that directly impacts a citizen.
Right.
So therefore, it's since decades, Supreme Court has tried to draw a balance between the rights of the prosecution, because they would obviously want custody of the accused person, and the right of the accused person whose personal liberty, which is a constitutionally enshrined right, is protected. Now, we've had CRPC which enshrined these principles.
Right.
For anticipatory bail, we had section 438, and for more serious regular bail, we had 439 and even 437. They laid down broadly the contours as to when you could get bail and when bail was denied. Now what happens is we have these two very special laws, if I can say so, not just merely special, but very special laws, which has, if I can use that term, altered the balance.
Right.
There is a disruption in the balance, because now these two laws, that is the PMLA Act of 2022, 2002, and the UAPA, the Unlawful Activities Prevention Act of 1967, both of them have engrafted certain provisions which have made grant of bail extremely difficult.
Right.
So that level playing field, or that balance that was there, a very fine balance, that stands disrupted.
So basically, just to give a context to our viewers, there are these two laws. One is the Anti-Terror Law, or the Unlawful Activities of Prevention Act.
Yes.
And second is the Anti-Money Laundering Law, which is the Prevention of Money Laundering Act.
Yes.
Now, I think apart from having a very wide definition of the offences that get covered under these two laws, there is the provision regarding the bail is extremely stringent.
Yes.
As you just mentioned.
Yes, you're right.
So why do we call this provision regarding bail stringent in these two laws?
Yes. So, as I said earlier, before these two laws, and the general provisions of CRPC applied. So, if you wanted anticipatory bail, you move under section 438. If you had regular bail, you moved under 439. And the courts used to apply what is known as the tripod test, a triple test.
Yes.
Consisting of whether before granting bail, they used to see, apart from the heinousness of the offense, they used to see that the accused, whether is he a flight risk?
Right.
Will he tamper with the evidence? Will he tamper with the witness? These were the three probabilities or the factors the court is to consider before granting bail.
And I think with the way to make sure that the accused or the under trial is present during the trial.
Yes,
so the idea of bail is...
So flight risk. So gets covered under the first point, that is flight risk. Then whether will he tamper with evidence? Is he an influential person? Does he have the propensity to do that? Or will he tamper with the evidence? Because if you are well connected, or if you have certain resources, quote unquote, then during the trial you can always tamper with the evidence.
And the triple test principle applies irrespective of the nature of the offense.
Yes, broadly. You can still draw a distinction. Say, for example, in murder cases, despite these triple tripod tests, courts were very wary of enlarging you on bail until the entire trial didn't get over. Or, for example, in say rape matters, until and unless the evidence of the victim, the prosecutrix as we call her in law, until her evidence was over, the court never granted you bail. But in other matters, broadly, once the charge sheet is filed, means the investigation is over. means you don't need now the custody of the accused person.
Hmm.
Then the court is to apply this tripod test to see that, okay, now the stage has come where he is entitled for bail. But before I enlarge him on bail, I have to see whether is he a flight risk, should not be take the bail and scoots, runs away from the country.
Right.
Or if I give him bail, he'll tamper with the evidence and see that the trial becomes in his favor illegally, or whether he will threaten the witnesses and see that the evidence doesn't take place. So so these are the three broad parameters. If the court felt that no, he is a major problem in these three areas, the court is to still deny bail. But broadly, bail was granted, except, as I said, in very heinous offenses like, say, rape or murder. Now what has happened is, with these two laws,
UPA and PMLA.
UPA and PMLA, bail has become a very highly discussed aspect. Why? Because, as I said, section 43D, D for Delhi, 5 of the UPA, which prescribes as to when bail can be granted, and section 45 of the PMLA. So these two provisions, which provide for bail of those people charged under UPA or charged under PMLA, they have raised the bar considerably for grant of bail. So what these two provisions have engrafted, they have said that firstly, public prosecutor will have to be heard. Without hearing the public prosecutor, you can't be given bail. And then the twin tests, the twin test which we read in the newspapers very often. Twin test is whether the court has to form a view that whether have you prima facie committed this offense, and secondly, whether if I release you on bail, will you still commit this offense or no?
Okay.
Now, these two things are extremely difficult for any trial judge to decide.
Okay.
Now, how is the trial judge going to decide? Because see, when the trial judge has to decide, there is no evidence before him. There is only the charge sheet that the prosecution has filed. So the entire stories of the prosecution, there is no story of the accused. So he has to decide bail of the accused based on a material which is inherently inimical and antithetical to the accused. And then based on that material, he has to decide that no, this material is such that prima facie gives me a view that he has not committed this offense. For a trial judge to say that before trial requires something, either the case must be very flimsy or requires someone.
So is it that the defense doesn't get any opportunity to even rebut the arguments when bail is being argued under these two laws?
It can't, because again, when we just proceed a little bit further on this, so firstly the provisions, let's see what 43D5 says and 45(1) says. It says that before granting bail, A, you have to see whether is he prima facie guilty, but whether he is prima facie or guilty or no is solely on the prosecution documents, not on the accused documents.
Right.
And B, if I enlarge him out on bail, is there a possibility he might do the same thing? Now, how is the judge going to conclusively say this, that if I enlarge him in bail, he won't do this? So therefore, these provisions engrafted were very difficult. Now, coming to PMLA, what happened was PMLA, these provisions, section 45, which are the twin tests, was challenged before the Supreme Court. And Supreme Court, in a very landmark judgment in 2017, Nikesh, Tarach and Shah said that this twin test is unconstitutional.
Okay, it was declared unconstitutional.
But this places the bar too high. No accused can get bail. So therefore, they struck down these twin tests. Now, the government, a few months down the line in 2018, again amended PMLA to reinsert this.
Right.
Broadly, as in layman's terms, because the Supreme Court did make certain observations with regards to the tenure of the offense. So the government took cue from that and exploited a technical loophole to again get these provisions back, saying that no, Supreme Court said it only when there is for 3 years offenses. We are now making it across the board.
Okay.
So these the twin tests, which were to be scrapped under 2017 judgment, were brought in again in 2018 by an amendment. Now, then that got challenged. And the challenge was decided by a 3-judge bench, because Nikesh, Tarach and Shah was a 2-judge bench judgment, Justice Nariman and Justice Kaul. So there was a 3-judge bench judgment, a very landmark judgment, a pretty 545-page judgment, that is Vijay Madan Lal Chaudhary.
Yeah.
Now that judgment, if there was a tilt towards the prosecution, that judgment yanks it in favor of the prosecution, just pulls it. Totally in favor. So nothing is left for the accused persons except to wait for the end of trial before they can even get a whiff of bail. And trial can take years. Like we've seen recently in the case of very important political personalities, they've been incarcerated for almost 2 years. And the trial hasn't commenced.
So that is PMLA, where you just mentioned that how the Supreme Court in Vijay Madan Lal Chaudhary upheld the bail, not just the bail provision provided in PMLA, but all the other sections of PMLA, giving sweeping powers to the Enforcement Directorate to go and arrest people without even, providing them or supplying
Correct,
them a
correct.
copy of the
Copy of the
first information report, as we
ECIR.
say.
Yes.
But there was also a judgment with regard to UPA,
Yes.
which it is said is again raised the bar even higher.
Correct.
Can you just
Yeah,
reflect
so that
slightly
is,
on
yes,
that judgment
you're right,
as
Bhadra,
well?
absolutely right. There is a twin judgment. So there are a twin test and there's a twin judgment. So the twin of Vijay Madan Lal Chaudhary is Zahoor Ahmed Watali, a National Investigating Agency NIA versus Zahoor Ahmed Watali, a 2019 judgment where the Delhi High Court had granted bail under UPA, and which the Honorable Supreme Court scrapped it and said that when you have to grant bail under UPA, you just have to look at the contents of the charge sheet that is filed. The trial judge cannot venture into the merits and demerits. He cannot form a personal opinion that no, this doesn't seem to be very plausible. He has to take it as the gospel truth, whatever has been filed, and then on that basis see whether the accused is entitled for bail or no. Which, as I said, again, it will be practically impossible. So therefore, Watali still holds the field. So in UAPA cases, it is, and another one very important distinction, Bhadra, in UAPA cases, there is no anticipatory bail.
Okay.
So it's even more difficult.
Okay.
At least theoretically, whether you get it or not is a separate question. But in PMLA, that is money laundering, there is a provision for anticipatory bail. But in UAPA, by virtue of 43D4, anticipatory bail is totally out.
Right.
So before arrest, if you are apprehending arrest, you can't go to court and seek for bail.
Right.
So you get arrested and then you can only hope to get a regular bail. In regular bail, Zahoor Ahmed Watali's judgment says that the trial judge has to see the contents of the charge sheet, take it at absolute gospel to the Gita and nothing beyond it, and then decide the bail. The trial judge cannot at that stage decide that no, the accused is prima facie.
So is it for this reason that it is said, that the onus to prove is
correct.
reversed?
Yes.
So
You're right.
unlike
Absolutely.
the regular criminal cases where the burden is on the prosecution to prove the case, even during the trial, they have to rebut the arguments of the accused. As far as UPA and PMLA are concerned, it just reverses.
Correct.
The burden is on the accused to rebut the prosecution. So now, since you've given a background regarding the two judgments as well as the two laws, let us come to the recent judgments by Supreme Court. We have noticed that in the last 2 years, in connection with both the laws, the UPA as well as the PMLA, the Supreme Court has been delivering judgments emphasizing the fact that bail is the rule and jail an exception. It started, I think, in 2022 with Justice Ramana's judgment in Najib's Najib's case. So it is being said, that the law that was set out after these two judgments were delivered, one is the Vijay Madan Lal and the Zahoor Watali judgment. It is said that the recent judgments has actually watered down these two earlier judgments, slightly tilting the bail jurisprudence in favor of the accused as far as these two laws are concerned. Can you just reflect on the judgments?
I can't say tilting in favor of the accused, but yes, the tilt which was heavily in favor of the prosecution, there has been some course correction. And see, beyond a point, you can't blame the Supreme Court because the provisions of the Act are so stringent.
Right.
Now, it's a catch-22 situation for a judge. Because if he were to interpret the provisions of the Act as the Parliament has passed, then bail becomes almost next to impossible.
Right.
But then we have our constitutional imperative under Article 21, 20, 21, 22. There, as you said, the onus, this is actually flows from the Constitution. The burden to prove or the onus to prove is always on the prosecution. And there is always a presumption of innocence in favor of the accused until proven guilty.
Right.
What these offenses are practically doing is reversing this age-old tradition, is making them accused or making them guilty until you're proven innocent.
Yes.
So therefore, Supreme Court had to wade through a maze of all these amendments and these case laws and then to try and find a way out, which Supreme Court is taking small but very sure steps towards it. It is recognizing that it needs some course correction.
Can you just explain how it is doing it, how it is coming to the aid of the accused in these kind of cases?
So one way in which it has, there have been certain principles that the Supreme Court has devolved. For example, in October 2023, we had one Pankaj Bansal's case in the Supreme Court with regards to bail under PMLA. And there the Supreme Court said that the grounds to arrest a certain accused persons have to be clearly furnished. You can't just do a haphazard job about it. It's not just merely a procedural thing, it's a substantive right. So, and if you have not informed the accused the grounds of his arrest and arrested him, then in that case, your bail can be granted. So that's one exception Supreme Court has carved
Yeah,
out. As I said, the course correction. Then another exception, Tarsem Singh's judgment recently in the Supreme Court, which said that once a cognizance is taken by a criminal court, then you can't go ahead and arrest.
Okay.
So till the time the ED has the right to arrest, till the time the cognizance is not taken by the special court.
Yeah.
Cognizance means the special court is now seized of that matter. Once the special court is seized of that criminal case, then you cannot go and arrest unless and until you have the permission from the special court, because special court will take cognizance only when the investigation is over. So once the investigation over, where is the question of arresting somebody? So Tarsem Singh's judgment is another exception carved out. Then Prabir Purkayasta's judgment, NewsClick's founder, belongs to the media. So his bail also was granted on lines similar to Pankaj Bansal.
Yeah.
And then
where the grounds of arrest were not informed to him.
Absolutely. And then you had Manish Sisodia and Arvind Kejriwal. These are the lines
So,
of judgments.
in Manish Sisodia, the court has
Yeah,
spoken about. Sorry.
when we mean Manish Sisodia and Kejriwal, we mean the case law, not the persons.
No, of course, yes.
Yes.
Yeah. So in Manish Sisodia's case,
Yes.
as we all know, his arrest is under the Delhi excise policy case.
Yes.
In Manish Sisodia case, the bench headed by Justice B.R. Gawai has extensively dealt with the point of, right to speedy trial.
Yes.
And that if there is a prolonged delay, then the accused, irrespective of the nature of offense which he faces, is entitled to bail.
Yes.
Can you just slightly discuss this judgment?
So they have. It was a very exhaustive judgment, and it's actually dealt with all the issues emanating out of bail jurisprudence with regards to PMLA. But as I said, by the time a matter reaches up to the Supreme Court, you have to go through the rigmarole of the special court, that is the trial court, then the High Court, then the Supreme Court.
Right.
Then notices are issued, responses are filed, matters are fixed for argument. So the process is such that the process itself is the punishment.
Yeah.
After conviction, what you get, or if you get convicted or no, a separate issue altogether. But in these prosecutions, the process itself is so painstakingly elaborate and slow that that itself is a punishment. So that is what, after examining all, and in fact, the examination of the Supreme Court is in the facts of this case, where for 17 months he was behind the bars, and Supreme Court said that the trial hasn't progressed, let alone commenced. And therefore, Supreme Court said that the facts which are unique to that case makes out a clear case for grant of bail.
Right.
Now, the Supreme Court can say that because that's the final court of the country. But I still have my doubts how much a trial judge can venture out and say that.
Okay.
Because although theoretically they are seized of the same bail provisions, they can decide it. But of course, Supreme Court being a constitutional court, those judges there would have far greater powers to exercise compared to a trial judge. So I think unless and until we don't revert back to the 2017 status of Nikesh Tarachand Shah, where both these twin tests were struck down, we can't expect trial judges to, despite this salutary observation from the Supreme Court, I don't see in the foreseeable future trial judges being liberal with bail.
But why is it so? Because, just a couple of months back, we had another judgment where another bench during the, summer vacation of Supreme Court had very specifically spoken about right to speedy trial. In fact, in that case, the NIA was the prosecuting agency. UPA was the law that was invoked against the accused. And in that specifically, the bench had observed that if the prosecuting agency cannot ensure speedy trial, then the prosecuting agency has no right to even oppose the bail. So who is responsible to ensure that the trial should, pace up so that it ends and the person receives some sort of justice either ways?
Correct. No, but see, the problem here is the question as to has the trial proceeded at the requisite speed or no. When the case is before the trial court, it is day 0. When it reaches the Supreme Court, it is say day 100. So when it reaches the Supreme Court, you have a clear idea as to what has happened in the last 3-4 months. Has the trial proceeded? No. So Supreme Court does grant bail. But when the matter is at a very incipient stage, in a very initial stage, it's difficult, I believe, for the trial judge to say that how, because the trial judge would go by whatever the prosecution says. They says that no, we may have cited 100 witnesses, but we are going to lead evidence of 10 star witnesses, and we'll get it done in 3 months' time. So you don't give him bail, keep him behind. Now what does the trial judge do? You see, so the provisions are such, they're so draconian that that beyond a point, despite this encouragement from the Supreme Court, I really wonder how much the trial judges are going to really adopt it, because in every case they are going to be faced with 43D5 and with 41(1) and 45(1), and to get over those hurdles is a very substantial task.
So what you're suggesting is that unless an extreme measure is taken by the Supreme Court, just like it was done in 2017, where the twin conditions, the twin tests under PMLA were, so till that point of time, it's very difficult to expect the trial courts to follow suit, despite the Supreme Court making observations about not playing safe when it comes to granting bail and protecting the liberty of the citizen. Sunil, I just want you to also explain very briefly. You just mentioned that the procedure in UPA and PMLA cases can be a punishment in itself. Can you, for our viewers, just make us understand why is it that the procedure in under these two laws takes so much of time? They are like any other criminal offense.
See, Bhadra, unfortunately, our criminal courts are absolutely overloaded and flooded with litigation. So, even in a normal criminal matter, let alone UAPA or under PMLA, a normal criminal matter also takes years in the trial court, let alone High Court and the Supreme Court. Why go far? Even a simple check bouncing case, which is predominantly it's an open and shut case, either your check has bounced or not bounced, even that takes 3 to 4 years before, from the time you file that case in the magistrate's court till the time you get either a judgment in your favor or a dismissal. So if a simple check bouncing case takes 3 to 4 years, imagine what would be the state of other serious offenses. So it's not something unique to to PMLA and UPA. The general criminal infrastructure in our court infrastructure in our country is something which is extremely overloaded. The docket is extremely heavy. So despite the best efforts, it's just not possible for things to move. Number one. Number two, the age-old maladies that afflict our court system, be it civil or criminal, that is adjournments. That is also another problem. Multiple accused persons, they will have 10 accused, will have 10 lawyers. Or even given one day, one may not be there, two, the second day, the other guy would not be there. Sometimes the IO hasn't come, sometimes the PP is unwell. So you see, and then you don't get, it's not on a day-to-day basis that the trials take place. So even if you are able to give one date per month, and that date is lost, you straight away, that month is lost. So therefore, it's in cases other than UPA and PMLA, it's anywhere a very convoluted, very contorted, torturous process. What makes this even worse in these two matters is that bail is so difficult. At least in other matters, you can get bail and then stay out. Your liberty is protected, and then you go through this rigmarole, a bit torturous rigmarole of the criminal prosecution. But in these two cases, you are inside. And then you have to undergo the torturous rigmarole of criminal prosecution. So it's inherent in the procedure, it's inherent in our system that and despite having special courts, despite that, I mean,
you have dedicated courts for UPA and PMLA trial.
Absolutely. But even if you have dedicated courts, the charge sheet comes into 1 lakh pages. The prosecution files charge sheet with his 1 lakh, 2 lakh, 50,000, 25,000. Now, how do you expect a trial judge to have a trial conducted on a charge sheet? The least they go is say 5,000. Even a 5,000 pager charge sheet to have, and there are 50, 70, 80 witnesses cited, to call them, to have their chief, then cross, then hear arguments, etc., etc. The process is pretty long. So that itself is the punishment.
So all the more reason that we need to water down the bail provision in these two laws, I
No, I
guess.
would say, see, although yes, I would like to strike a balance here. I understand the prosecution also has very important objectives. We can't just look at it from the accused point of view, and we also have to take care of the prosecution's point of view.
Right.
And that's why, personally, my personal view, I earnestly believe that our CRPC,
The Criminal
Criminal
Procedure
Procedure
Code.
Code
Yeah.
1973, did, and of course, even the successor
Even the
statute,
new
yes,
new
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 one,
procedure law.
it
Yeah.
did contain enough safeguards in such situations.
Okay.
You need not have gone exceeded it. And what was the reason? Please also understand this. The reason why suddenly these two laws have become so much in news is, we had this infamous the Mumbai terror attacks in 2008 November.
Yes.
So after that, in order to make it more stringent against terrorists from our neighborhood, UAPA was amended in
Yes.
December of 2008, and this 43D5 was inserted.
Yes.
So its purpose was something else. Then again, with regards to PMLA, it was got about in 2002 because there is an international task force known as the FAFTF, the Financial Action Task Force, under which it's a global endeavor to ensure that money laundering on a trans-border basis is stopped, because one of the major reasons after 9/11 they discovered was money laundering, that finances were moving around so easily. So this FAFTF started after the 9/11 in order to curb the menace of international money laundering.
Right.
So therefore we enacted PMLA in 2002. So look at the origins of these two statutes and see where have they ended.
Right. So it's basically the problem is with the
Yes,
implementation.
implementation
The
also.
objectives were laudable,
Yes.
but the implementation has been a problem.
Yes.
Well, thank you so much, Sunil, for joining us at ThePrint and explaining so lucidly the two laws that have become very contentious over the years, as well as the recent judgments where bail is the rule, jail an exception, has been reiterated by the Supreme Court. Thank you so much for joining us.